And the session is now, there you go. You now have the session recording. You can also have a transcript in there as well if you wanted to have subtitles. By all means, you are more than welcome, of course, to do that. Take any notes that you need to throughout. As I said, for those who've just joined, the session will be recorded. So if there's any information which you miss, or if there's something that you wanted to pick up after the session today, or if you wanted to have a little bit of a refresher, you absolutely can do so. So without further ado, the time has just ticked over to 12:30, so we will begin the session today. And looking at, as you know, when is a director personally liable? And particularly looking at D&O, or Directors and Officers Insurance. The reason that I wanted to do this session this month around D&O is because there's so many changes that are happening in the world, right? In terms of legislation, in terms of health and safety, in terms of what precedents are set when it comes to case law. And the world and things like ESG, environmental social governance, distribution chains and things of that nature. So I want us to look at this today, and I think it's a really relevant topic, not just necessarily today, but I do think that it is something that is becoming more and more apparent to clients, shall I say, because they're a lot more aware of the risks which they, well, actually, probably yes, and probably a little bit of no as well. More risks that they should be aware of, but then the question is, I guess, is are they aware of the risks which they either have imposed on them or just generally aware of what it is they need to do as a company director? I think it's so easy to become a company director. All you need is like 50 quid, or has it gone up now, £100 maybe, to set up that limited company. There are changes in tax regulations as well now, which are happening, which are imposing around how often submissions need to be made. But I think that it's very easy for someone to just go, yeah, I'll set up a company. I'll set myself up as a director and a person with significant control of that company, without necessarily realizing what the implications are. And it can be quite risky. So when we think about SME type clients, particularly, I think, at least anyway, the majority of clients that we would sort of deal with, as it were, when I say SME, we're talking about someone with less than 50 employees with a turnover of and a balance sheet of less than 10 mil. So it's really relevant, and just to kind of make that up as well, 99.9 or 99.5. I think it's 99.9. I may stand corrected on that. I need to have a little check. Businesses that are made up in the UK are of that nature. So it's a huge exposure. There's a huge appetite for it as well, I guess. But the reason, the sort of core reason around this is to help our clients become very aware of the risks which they face, to then recognize, oh, do you know what? I didn't really think of that. And yes, there are protections in place, such as buying an insurance policy like this, for risks which they don't necessarily see. And what I mean by that is they can see property, they can see stock, they may be aware of their liabilities from a perspective of employing people, because we're told that we have to do that, right? Injury to employees, things of that nature. Injury to members of the public. But are they aware of the risks which they carry as a director or an officer of the organisation? So that's really what I want to cover off today, and therefore we've got three sort of learning objectives. First thing I want us to do is to identify the circumstances under which a director or officer can be held personally liable. People set up limited companies on the basis of, oh, it's different, it's a separate entity, which of course is correct, but that doesn't necessarily mean that they can always hide behind that corporate veil. There are their personal actions and what it is that they do as the company director, which can ultimately lead to some form of action that is brought against them. What we'll discover as well throughout the session is recognizing that not every action which is brought against the director is one that has a claim paid out on it. One key feature of D&O, and we'll get into this as we move through, is that it doesn't just necessarily pay for any damages or compensation which is owed, but it will also pay, and the key part of it is defending that claim. A legal expenses policy will not do that, because the legal expenses policy are for disputes mainly. You can buy legal expenses in terms of like employee contract and disputes and things of that nature. But this is specifically for the actions which they cause as a company director. The second objective which I want us to cover off is to understand the client's risk profile, to know where and when D&O should actually be offered and when we should actually be raising the conversation to the client or the prospect around it. Again, making them aware of what risks that they actually have, which they may or may not be aware of. And then finally, explore the core structure of a D&O policy, because it works differently. It works differently to how property insurance works. It even works differently to how public and employer's liability works. The structure of it is different. How the claims are paid are different. And therefore, how the policy then needs to be broked and put out into the market also is slightly different. Not to mention about capacity and the insurers which actually provide this risk. So it forms in a very similar way. Well, it falls within the financial lines product, even though it's a liability policy. Think of things like cyber, think of things like professional indemnity. Its structure and its makeup is a very similar structure to it. So how are we going to get there? So 4 key chapters, I guess, that we are going to look at today. First thing, let's dive into the world of a company director and let's understand what it actually means to be a company director, what laws are imposed on them, what does various pieces of legislation state that they need to do. Then we'll move on to understand how liability can arise, and we'll be looking at who can actually bring an action, why would they want to bring an action. We'll also be looking at various case studies as well, because I really like to do case studies because they really paint a bit of a picture. And for me, that is a lot more relatable than just, this is what could happen. If we look at real life cases, then that is the, image for us to then go, oh yeah, actually, I do know someone who works in this kind of line of business or does this kind of thing. Then we'll get into the policy intricacies. So we'll then have a look particularly around claims made and recognize things like retroactive dates, recognize claims made versus claims occurring. And then finally, we'll have a look at underwriting and broking the risk. All right. So let's dive in and let's have a look at the world of a company director. Now, before we actually get into this, first thing I want us to remember is are different legal entities. So the key idea around directors and officers insurance is that when we think about the target audience of it, we are predominantly looking at companies with a separate legal entity. In other words, those companies that have its own individual identity, they're registered on Companies House. Think of private or public limited, it doesn't really matter. Limited liability partnerships. You may even think about things like clubs and associations. Ultimately, a company that is separate for those or to those who run it. Now, therefore, the director then doesn't necessarily become the owner. The separate entity is owned, typically speaking, by its shareholders. So when we're talking to people around D&O insurance and they're a sole trader or they're a partnership even, D&O insurance is not suitable for them. The reason being is because they are not separate from the company. Any profits, any liabilities, any taxation, whatever it is, it's not separate to the person who ultimately, as a sole trader or a partnership, own it. So that's the first thing that I want us to remember before we actually begin this chapter. All right, what we are talking about here are companies with a separate legal entity. Now, let's begin this chapter with looking at the different types of directors. Now, as we know, a director is someone or is a person who is appointed to manage, to run the company on behalf of its shareholders. In law, directors are often described as agents of the company. And what that means is that they act on behalf of the company, not themselves. So they have to do what is right for the company. And I want us to remember that because we'll talk about the Companies Act of 2006 in a minute. And there are so many different sections. We're particularly going to be looking at he says 6 or 7 key things which the Companies Act imposes on the company director that they have to do. So, first thing that we have is an executive director. An executive director is someone who is involved in the day-to-day running of the business. They can be an employee as well, but something to also understand and to think about is that the D&O policy is exactly that. It's not just a director's policy. It's also an officer's policy. So when we say typically also an employee, if you have someone in an organization who is responsible for the day-to-day running of the organization or the direction of the company to where it's going, applying its strategy, applying its direction, how are we going to get there, the processes in which we get there, it doesn't have to be a director. You can have somebody without a director title that can also be held liable for certain things, and we'll get into that later on today. All right. So just because someone doesn't have the name or the title of director doesn't mean that they are excluded from being held personally liable. For example, if you have someone who is a HR manager within the organization, for example, okay, they can also be hiring, especially if they are responsible for hiring people, performance reviews, promoting people. They can also be held personally liable. All right. So executive, day-to-day running of the business. We then also have a NED or a non-executive director. These are ones that sit on the board, and they sit on the board as an advisory or kind of like an oversight capacity. They're not involved in the day-to-day operation, but typically they're appointed because they have a particular area of expertise, and they have someone who has come in, or the board has asked someone to come in from an outside perspective and to make sure that the governance of the company is done right. So they won't get into do this, do that, do the other. Very much, have you thought about this? Almost like on an advisory bit. Oh, we can't do that because it goes against ABC. So very much on a advisory basis. We then have a de jure director. Now, a de jure director is someone who is sort of, well, they labeled or listed, I should say, that's the word I'm looking for. They are listed as a company of a person of significant control on Companies House. They are actually listed as a director. But what I'm really also keen, and this is where the employee part comes into it as well, is that we can also have a de facto director. And this is someone who acts as a director without being formally appointed. Now, the same duties apply to them, even though they aren't necessarily what's the word? They aren't necessarily appointed or have the title. They have the same responsibilities. Ultimately, think of it this way. If the company director who is running the company, they have all of these things that they need to do, and that is physically impossible for them to do it, right? Maybe or maybe not. And they may have a sufficient amount of capital and cash flow in order to then allow those responsibilities. Number one, the risks grow. And second of all, those responsibilities to then be delegated to somebody else. And it's that delegation, just because that person doesn't have the title, it's that delegation which then ultimately allows them to then become or recognized as a de facto director. Okay. Now, this is a very, very important point, right? A client may say, oh, it's just me, or we don't have any directors, or, something like that. But if there are individuals giving instructions that the company then ultimately follows in terms of who are we recruiting, do we think about apprenticeships? How do we get involved with various learning bodies? Because I can't do the training myself, I have to point that out to somebody else. Then they have that same exposure. All right. Depending on the size of the organization, it may also be someone who has a particular level that is given to them. But ultimately, if they are pointing or they are directing the company, then they are exposed. Now, something to think about when an organization is formed is that they should have an article of association. Now, the article of association it's the company's internal rule book. It is a legal document that sets out how a company is run, how a company is governed, and how it is controlled. I'm saying that they should have them because every UK company must and should, right? And they can either use the standard sort of model articles, and you can find them on the government website, and they are provided under the Companies Act of 2006. But that doesn't necessarily stop them from having a bespoke version to tailor it specifically for that company. All right. So think of it as a constitution of that organization, of that company. All right. The company sets the law that applies to all companies. And then that article of association then sets out specific rules on how that company is then going to apply to those laws that are set out. All right. So in that article of association, what you will find in there are the director's powers, what the board has decided to do with and without shareholder approval. It will also outline in there what needs shareholders' votes. It will also outline the appointment and the removal of those directors, so how a director then becomes appointed, and the process in which the company needs to take in order to remove one. Shareholders' rights will also be in there as well, things like dividends rights, voting rights, different share classes as well. Meetings, how the board meetings and the general meetings are called, how they are run, company secretary that has been appointed over it. Share transfers are also included in as well, who can actually sell those shares. But one key thing to also understand with the article of association is that it also outlines the indemnity and the insurance provisions. Now, if a action is brought to a company director, that company director, under the article of association, needs to ultimately pay for to defend themselves and also for any compensation which may be awarded. It doesn't go to the company. If that company director has been named in the action which is brought against them, then therefore it is the director which is responsible. We've just talked about that. Now, the article of association will also then outline what the company is able or not able to indemnify the director for. So, for example, if the company director has an action that is brought against them, the article of association will allow and can allow the company director to be reimbursed for any expenses that it has had to defend itself against that action. So ultimately, the director has to pay it, but then can get reimbursed by the company or indemnified by the company. Now, there are certain requirements and there are certain rules that apply to that. The first one is that the company can only provide the indemnity if the company director has been held as not liable. So that's the first one. So when we think about that, what it will only actually really apply for or indemnify is the company director's non-fault defense costs ultimately. Okay. It does not allow the company to pay for any damages. So if they have been found liable, what cannot happen is the company cannot reimburse any compensation or damages that have been awarded in that action. Okay. And that's the first thing to think about, because that's exactly what a D&O policy will actually allow it to do. Okay. The D&O policy will pay for those defense costs, and it will pay for those damages that have been awarded and any compensation as well. All right. The D&O policy will pick that up. The Article of Association does not allow the company to do it. Now, the reason that I'm talking about this now is because the structure of the D&O policy, when we talk about that later on, will understand who the policy will actually indemnify. Does it indemnify the director, or does it indemnify the company? Purely based on that setup. Okay. So remember the corporate veil. It's that legal separation between the company and the people who own and run it. In most circumstances, then that veil protects directors and shareholders from personal liability, but the veil can be lifted. Courts and regulators can pierce that veil in circumstances such as fraudulent or wrongful trading, personal guarantees that have been given by the company director, acting outside of their scope of authority that is set out within the Article of Association, any breaches to statutory duty that have been imposed on them, such as Health and Safety at Work, etc. Act of 1974. So this is where the directors and officers' exposure then starts to take that shape. Okay. So the director has three sort of key areas of responsibility, right? First thing, that they have a responsibility to the company, and this is outlined under the Companies Act of 2006. They then have a duty or responsibility to the government and the state. Various UK and EU laws. We're going to be looking at these, so don't worry about them too much for a minute. We're going to be looking at these in a little bit more detail in a moment. But just because, even though that company may have even wound up, and this is also very important, particularly with how the policy is actually structured. Even though the company may have, or is not trading any longer, maybe it's wound up, maybe it's sold on, maybe it's even gone into solvency. That doesn't, just because they are no longer a company director, does not mean that they avail themselves from their responsibilities. Even after direct company directorship, they have a duty to any creditors, but also GDPR as well, because there'll be sensitive information that they will deal with that they have to keep according to GDPR and Data Protection Act of 2018 here in the UK. So let's look at each one just to make sure that we're happy and just to kind of give a little bit of a flavour as to what they are. So the Companies Act of 2006. So we can see them all across there. And the whole sort of purpose around this really is that it's that legal obligation to act in the best interest of another party. And that is exactly what a company director is to do. All right. Directors are ultimately fiduciaries of their company. And this means that their personal interest must never come before the interest of the company that they serve. And any breach of that fiduciary duty is one of the most common triggers for a claim against a director's or officer's insurance policy, and is the key exposure to which insurers actually see and look to pay and defend those claims. Now, the Companies Act makes it very clear of what those duties are that the director owes to the company. So there are 7. So first thing, to act within powers. So again, these are specified within the company's Article of Association. They can and should only be exercised for the purpose that was intended. In other words, for the goods of the company rather than the individual director concerned. All right. Is it the right thing to do for the company, or am I going to personally benefit from it? Okay, so we can start to kind of see how these things can play out, right? Especially with small businesses. Maybe try and get as much money as possible. You know, they've got to survive. Of course they do. but also from a perspective of where do I get my business from? Is it that people that I know? Is it people within my network? So we can see how the lines can sometimes be a little bit blurred. They've also got a duty to promote the success of the company. So the director has to promote the success of the company to the benefit and its members as to benefit the members as a whole. So whenever making any decision, what a director has to consider are things like the potential long-term consequences. If I was to take this action, what would the long-term consequences be for the company? What are the interests of my employees? What maintaining a good company reputation? The need to promote good relationships with suppliers, with customers. What impact does that company have on the environment and the local community? How do I act fairly between members? Treating those with fewer shares in the same manner with those with large shareholdings. So a duty to promote the success of the company, and quite a lot goes into that. We then have the duty to exercise independent judgment. They have to consider all members when exercising their judgment, rather than either an individual or a particular group of shareholders. A duty to exercise reasonable skill, care, and diligence. I think that one goes as it says on the tin, really. And this applies to both executive and non-executive directors. Anyone with specific training, skills, experience would, as what would be reasonably expected to apply to them in their directorship role. Okay. What is the expectation of that company director? The duty to avoid conflicts of interest. I think we've kind of talked about this one already. And that includes either any actual or any potential, either situational or transactional conflicts, as well as direct and indirect interests. Now, if that conflict has been disclosed, the company's constitution then may allow the board to approve it, as long as it is sanctioned in the right and proper way. So just because there may be a conflict of interest there does not necessarily mean that we can't do it. It just means that it needs to have approval and it needs to be brought to the attention of the board and members to ultimately approve it and to allow it to happen. To not accept benefits from third parties, and this can be quite difficult to gauge. What is the difference between accepting a benefit and then simply trying to get that good relationship with customers and suppliers? Some companies, you may even have these yourselves. Some companies will have a written policy to clarify those situations. When is it appropriate to accept a gift? When is it not appropriate to accept a gift? Maybe there are certain limits to which it will allow it to do. They have to be declared, and so on and so forth. And then finally, to declare an interest in a proposed transaction or arrangement. So the interests must be declared before the company can enter, if there are any, into that transaction or arrangement. And the company's article of association will then set out what procedures and what requirements that it needs to follow to do so. And therefore, how should the board then deal with it in that manner? Now, the director is personally responsible to comply with these duties. Should a director or an officer breach those duties, then as we know, they can be held personally liable for any damages and liable to pay or to compensate for them. All of those duties can be found in the Companies Act. You can go and have a little bit of a look at it yourself. If you're interested in the sections, they are between section 171 and 177 respectively. Now, whilst there are statutory duties that are outlined in the Act does not explicitly exclude common law duties. Okay? Meaning that they can also then be interpreted in different ways. But common law must also be taken into consideration when interpreting the 7 general duties as well. Now, as they're all open for interpretation, we can also see that there is room for error. There are something like 192 pieces of legislation that a company director has to adhere to. Some of which you can find here. And of course, the Companies Act. And of course, this isn't a necessarily excluded list. Now, again, question for you. How many, you may even be a company director on the session today, how many, or even an officer, how many pieces of legislation do you know that you have to adhere to? How many do our clients know that they have to adhere to? As I said, it's relatively easy to set up a limited company, to have that separate entity, that separate legal entity. More tax efficient, maybe, but there's a whole lot that comes with it, not just those separation or just the separation. And people, I think, often think that, oh, I'm separate, therefore that's fine. Ta-da, I don't have to worry about it. No, they do, for reasons that we've just looked about. So we kind of see some things on there, the Insolvency Act, and that governs what happens when a company can't pay its debts, sets out specific personal liability regimes for those directors. Key exposures, things like wrongful trading. So if a director knew, or they should have ought to have known, that there was no reasonable prospect of avoiding insolvent liquidation, they don't take the necessary steps to minimize those creditor losses, then a court can order them to personally contribute to the company's assets. Fraudulent trading can also come into there as well, carrying on that business with the intention to defraud the creditors. That one can also sometimes shade into criminal territory too. Yeah, so lots of different kind of things in there. Health and Safety at Work Act 1974. That sets the general duty on employers with issues on health, safety, welfare of employees, and any others that may be affected by the business, any contractors, etc. Key exposures under here. They can be held and prosecuted personally alongside the company if any offence was committed with their consent, with their covenants. Ultimately, did they set it? There is a case which we'll have a look at some cases as well today, but I want you to go and have a look. It's quite a famous case. It was published and by the BBC. I say published. It was written about by the BBC. There was a guy called Simon Thomason of Clearview Design Limited, and he got held personally for corporate manslaughter. The reason that he got held, that he was found guilty of corporate manslaughter, is he had two employees, and actually had three employees working on the site, two of which died. The reason that they died is because they were in an industrial unit, and Simon Thomason, provided the team that was working for him as employees, provided it with carpet thinner, almost kind of like a removal of the carpet glue, right? You know those carpet tiles that you have in commercial offices, commercial buildings, thinners in order to remove that glue so the carpet could ultimately come up. It was rather dangerous and it was relatively cheap to buy. He didn't pay attention to the warnings on it. Also, knowing that the workers smoked, and it quite literally went up in flames, burning all three, but two actually died. The third survived with third-degree burns. He was sentenced to 6 months in prison for corporate manslaughter. So these things personally can be held liable. And another thing which we can also then think about is what happens, does that damage the company reputation? Is there a potential for, I'm just going to go back a slide. Oh, too far. Just going to go back to the duty to promote the success of the company. Is there a risk for having a claim from shareholders as well for damaging the company reputation and lowering, shrinking the value of the shares. Now, for that didn't happen because the shares were purely owned by Simon Thompson. However, what happens if it was a larger company where there are different shareholders? Okay, good. Employment legislation. So things like here we can think about unfair dismissal, discrimination, whistleblowing, um, company, basic employment rights, really. Directors aren't usually personally liable or, for ordinary unfair dismissal cases. Those generally sit within the company. But where a director then becomes personally induced is where there's been any breaches of employment contract, or if it is personally complicit with discrimination or harassing conduct. Okay. Data protection, I think we're all probably very familiar with that. The director has to ensure that they comply with how that personal data is collected, how it is used, how it is protected, with the ICO as the enforcer, the Information Commission's officer. All right. The Bribery Act of 2010, of course, creates that criminal offence for bribing or being bribed, bribing a foreign official, and critically, failing to prevent bribery. And Financial Services and Markets Act of 2000 as well. And this is the last one which we're going to look at. And the core sort of piece of that is underpinning that financial services regulation, the FCA and the PRA's rule books, senior management and certification regime, or SMCR, market abuse provisions. So, yeah, there are certain things which the company will also have to adhere to depending on what trade that they are or industry that they're trading in. So what happens if they don't comply with those? They can be removed as a company director, they can be struck off. There, of course, financial penalties, including fines. Now, this is important because the D&O insurance policy will not provide cover for those fines. It will only provide the cover for the compensation, if there are any awarded, and of course the legal costs with defending that claim. Recovery of financial losses, imprisonment, and even injunctions. So it's quite a serious thing, and there's so many, as we can clearly see, so many different pieces of legislation and so many things that they have to adhere to. And how many company directors know that they need to adhere to that? That's the question which I will ask. Are you alarmed by any? Were any brought to your attention? And as I said, it's not an exhausted list for the time that we have today. So what I do want to now jump into is understanding how liability can arise. So 3 key things to think about. First one, common law. Because directors, of course, owe duties developed by the courts over centuries: skill, care, and diligence, good faith, avoiding conflicts, plus liability in tort for wrongs that they personally commit while running that company. Much of that now, I will say, is codified in the Companies Act of 2006, but the underlying legal reasoning is still common law and equity. Okay. Second one which we have is statute. Now, of course, when we're thinking about statute, it's that the law that is in place. Parliament has layered specific personal liability provisions on top of those common law ones. Health and safety, as we just looked at, insolvency, as we've just looked at, Bribery Act, as we've just looked at, GDPR, as we've just looked at, right? So that statute poses them on the company director personally. Okay. These often lower the bar for personal liability, well below sort of, did you breach a duty? Sometimes it's simply, did you consent? Were you negligent in it? So rather than, did you have a breach? It's more now of, well, did you do it? Which sort of lowers that bar on where that liability can be held. Okay. I don't know if anybody remembers Carillion, the construction firm Carillion. When did it go into liquidation? 2008, I think. Oh no, maybe not as far. 2018. Sorry, 2018. I think it went. that was a really it affected the insurance market quite heavily, both from a perspective of D&O, but also from a professional indemnity perspective as well. The whole sort of consequence on this is that they were ultimately falsifying their profits. They were counting money for jobs that hadn't actually been done yet, and projects that weren't actually um, done or complete or even started sometimes, in order to try and inflate the value of the company for its shareholders. Um, and the insolvency service then started proceedings against the executive directors under the Company Directors Disqualification Act, which then worked hand in hand with the Insolvency Act framework. And ultimately, they were found liable for falsifying statements and increasing or looking to inflate the company's profits in order for its share price to actually increase. But they were in trouble. So they were being very creative, shall we say, with what their books were looking at. And then, of course, we have contract. Now, this is a category that is worth spending some time on to understand when we think about contract, and speaking to your clients to, really understand what contracts that they have. The reason being is because we often assume just because that contract is there, then it's fine. That's the agreement between the person and the customer or the supplier, whoever it may be. But it behaves differently from common law and statute. Now, the reason that it is different is because what a director then has to do is that if we think about personal guarantees for a minute, right? If a director voluntarily guarantees a company loan or a lease or a credit facility, if the company defaults, then the lender goes after the director personally under that guarantee. So that's the first thing which we have to think about. What do they have on loan? What lease agreements do they have in place? What happens if the company is not able to reimburse it? Well, the personal guarantee of the director, could they go after the company director for that? Okay. What happens if there are any personal warranties in sales agreement? Is a director selling their shares in a company? And if they do, does that give personal warranty about the financial position to that buyer of the share? If those warranties then turn out to be wrong, then the buyer could sue the director directly for that breach of contract. Okay. So when we think about who can actually bring these claims based on how that liability may arise, so many different people, so many different stakeholders. Employees, unfair dismissal, discrimination, unpaid wages. But as I said, if that director can be named personally and where they've personally induced that breach of the employee's contract. Okay. Shareholders, two main routes here. We have something known as a derivative claim, and that ultimately lets a shareholder sue a company on the company's behalf. So they ultimately come together collectively and will bring an action. So it's ultimately the company that is bringing an action against the director, but it's the shareholders which will action and enforce that in. Secondly, we could have unfair prejudice petition. So that lets shareholders complain that their own interests have been unfairly damaged by how the director has actually run that company. So as I said, a depreciation in that value of that share, if they are able to prove, and it can be proved, that the actions that the company director did was the result of the depreciation of it. Customers and clients, through the tort of negligence, misrepresentation, where a director has personally made any false statement that the client then relies upon, loses money because of it. Regulatory bodies too. We've talked about health and safety at work, the HSE particularly for that, the FCA for the Financial Services Market Acts. Creditors. We've talked about that one already. there's a case that you can have a look at called Dejan of London Limited. 1994 that happened. And the creditors come after him personally, even though the company was made insolvent. Basically what happened, Mr. Dejan, company director, signed a proposal form that was completed by their insurance broker. He didn't review it. He signed to say, yeah, that's all fine. The insurance policy was incepted. Later in the timeline, I don't know exactly when it was, there was a fire that broke out in the warehouse, damaging £174,000 worth of stock. The insurance policy failed to pay out. And the reason that the policy failed to pay out is because the question was, were you a company director that has been made insolvent previously? The question was answered no by the insurance broker. And Mr. Dejan didn't review that and therefore signed it. So it was stated that you've been negligent. It's your responsibility to ensure that the insurances that you have in place are accurate and adequate, and therefore to disclose them. Now, 1994, that's very important because this was, of course, before the Insurance Act, and for that one, because it was a commercial insurance policy, of 2015. So the policy or good faith was utmost good faith back then and traded under the Marine Insurance Act of 1906. That was the law that governed how material facts and information is to be disclosed, which turns them ultimately into warranties. And if you didn't do what you said that you would do, then you've breached a warranty, the policy is cancelled. And that's exactly what happened to Dejan of London Limited, 1994. Go and have a little bit of an explore if you need to. Of course, government, we've talked about that one as well. HMRC, directly from sector regulations. HMRC for any unpaid taxes, criminal prosecution brought under the Bribery Act. But even competitors, any rival businesses may also be able to sue a director personally for any economic tort committed to the company, trademark infringement, passing off, or unlawful means. Usually because the company itself may not be worth pursuing, but therefore has the director allowed that to happen. So you get the idea. Okay. So now that we know what the company director has to do, how they can be held liable, let's understand how these D&O policies are actually set up. So the whole purpose of that D&O policy, remember, it's to pay for and to provide cover for the director personally for any action that is brought against them as an allegation of their act or acts which alleges that they have breached their duty as a company director for all of the things and more that we've talked about. Remember, it's not just there to provide compensation. It is also one of the key things, and the majority of insurers will pay out in this aspect, are those defense costs. Okay, defense costs. Remember, fines and penalties are not covered by the policy. Now, the claims trigger as to where this will actually happen, and it's quite deliberately broad. So you can see there any actual or alleged breach of duty, breach of trust, neglect, error, misstatement, misleading statement, omissions, or other acts done or attempted by an insured person in their capacity as a director or officer of that company. That is the claims trigger. Quite broad, right? And insurers will usually want that trigger to almost catch any governance failings. It's not a narrow list, right? Just some examples that you can see on there on the bottom: breach of duty, neglect, omission, breach of trust, etc., etc. In their capacity is the real word that we need to kind of look at here. The wrongful act has to relate to the person acting as a director or officer. The director's purely personal conduct, unrelated to the running of that company, falls outside of it, and the D&O insurance policy will not pick it up. It has to be in their capacity as a director or officer of that company. Okay. And it usually extends to any matters claimed against them solely by reason of their position. So it's that sort of that catches company directors dragged into claims simply because of their role, even before liability is actually established. Remember, defending it. All right. So poor decision making, failing to check information properly, inadequate oversight of finances or operations, signing documents without reading them, missing any obvious red flags, right? And that is the sort of bread and butter of that D&O insurance policy. All right, that's the key, that's the sweet spot for those types of claims. Okay. Any personal interests that the company director puts ahead of the company's interests, undisclosed conflicts, diverting a business opportunity to themselves, accepting a benefit from a third party, self-dealing in a transaction where they have that interest. Could be a misleading statement. Think of Carillion. Okay. Could be investor updates, could be loan applications, could be inaccurate misstatements in a prospectus, any documents presented to a bank. Okay. So lots of different things which we can think about how these claims can come in. So how the policy will then ultimately pay and what it will actually look for and how and who it actually provides cover for is that it will protect the past, present and future directors. If we think about that the company doesn't dissolve just because that director is no longer there, directors can sort of come and go, and I'll use that term in air marks, right? Providing, of course, as a board approved by the board. So what this policy will do is not just provide cover for the present company director or officers, but any past and future. Now, this is important because when we think about how the D&O policy is constructed, and we'll look at that in a minute in terms of a claims made basis, then the policy ultimately needs to continue to run. Not only that, but an action that has been conducted by a company director 2-3 years ago may only now be brought to light. You know, sometimes these claims may not be immediate. And therefore, if that company director has no longer working or no longer a director of that company, or even working for the company, that doesn't exclude, oh, just, you know, what you've done previously, that doesn't mean that no claims can come in. So it will also provide cover for any past and any future directors as well, which may be appointed. And the reason being is because we'll look at that claims made basis in a moment. Provides covers for any new subsidiaries of the company. Be careful with these if you are broking them. They will have policy limits. In other words, it will say that the company cannot be bigger than 50% of the value of the company that you're actually insuring, or the subsidiary can't be more than 50% in size or value to the company, which, you know, to the policy holder ultimately. You still set these insurance policies up in the company name. All right, you still set them up in the company name. Protects the company with the repayment of legal costs. So remember, we talked about that the Article of Association is able to reimburse the company director if an action has been made against them. And therefore, if it has, then the D&O policy can reimburse or indemnify the company, not the company director. So it's one or the other. Think about that. It's actually formally known as Side A and Side B. Right? Side A will indemnify the director personally if they've are out of pocket. Side B will indemnify the company if the company has and is able to reimburse the director. So we'll always go back to the director. It's just who does it actually pay? Does it pay them directly or does it go through the company because the company's had to do it? Okay. Now, this is key. Cover is issued on a claims made basis. So let's have a look at how that claims made basis policy actually works. Now, the key feature to this is that unlike a typical public or not so much public and employers' liability policy, those are issued on a claims occurring basis, which ultimately means that if the policy, or it was at the policy that was in force at the time of the incident, is the policy which will ultimately pay for it. So, for example, if an incident occurred 3 years ago, it is the policy that was in force at that time, 3 years ago, that will pick up that claim. That is a claims occurring basis. D&O, PI, cyber, they are issued on a claims made basis. And ultimately, what that means is that you need to have a policy that is in force when the claim is actually being made, not when the incident occurred. Match the two words up if you ever struggle with this. Match the two words up to think, right, when was the claim made? Claim was made today, but the incident occurred 3 years ago. If its policy was issued on a claims occurring basis, it's the policy when the incident occurred. If it's the policy, same situation, if it's the policy that was issued on a claims made basis, like a D&O, it is the policy that is in force when that claim was made. Ultimately, if the claim was made today, it's today that the insurance policy, it's today's insurance policy which will pick it up, even though the alleged incident occurred 3 years ago. Which means that when the policy comes up for renewal, first thing, there cannot be a gap in cover. Second thing is a retroactive date. And third thing is that there needs to be a continuous policy because these claims could be made for quite significant time after, right? Depending on the Limitations Act of 1980. Now, the retroactive date is very important when it comes to claims made basis. The reason being is because that retroactive date will state when I will pick claims up from. Now, if we just look at this example, right, if a company was incorporated in June 2020, they took out an insurance policy for D&O in June 2022. That was the first time that they took an insurance policy for D&O. Therefore, it's the start of the retroactive date. It can't cover for past things because I don't know about them. You haven't paid for that protection. If an incident occurs in November 24, a notification of that action was brought in July 25, then fine, that claim will be paid because that incident occurred is after that June 2022. If that incident occurred, however, in July of 2021, the retroactive date is after the incident, which means that it will not pick it up. It will not pay it. Each time that the policy is renewed, the retroactive date will stay there. And ultimately, each year that you buy, the retroactive date will stay. It doesn't move with it. It will move. Now, this is why it's important to renew the policy on time with no gap in cover. The reason being is because if the policy comes for renewal, if it wasn't renewed, the insurers will go, well, that renewal offer has expired now. I'm going to need to offer you a new business. And because it's a new business, guess what you'll now have? A new retroactive date. So all of that work which has happened to build up that retroactive date, to build up that time, it's gone out of the window. So make sure that we invite renewals in good time and make sure that we outline to the client on how that actually works. So final thing before we conclude, key underwriting and broking information that we need to understand. When providing D&O, it's relatively simple, actually. We need to understand the company information. What is the legal structure? What is the turnover? Where do you work? What industry sectors? What regulations do you need to comply with? How many employees do you have? What is the number of directors that you actually have on the board? What is the financial health of the organization? What's their balance sheet, asset value, net worth, profitability? All of which we should be able, this is public information, and that's the cost, I guess, of becoming a limited company, right? Depending on the value, I will say that, but is that going to change? I'm not sure. Maybe so with the changes in making tax digital. Who knows what's going to come? The split and the number of directors that we have and who is what, the claims history of that organization, if they have any regulatory compliance, how do they comply with it? any corporate activity such as mergers and acquisitions which are happening, and of course the limit of indemnity that is required. Relatively simple information. And as I said, it's the information on the company. What is it they're looking to protect? And therefore, what information do I need to know? What is relevant? What is material to that risk? So, summary and recap. Hopefully, we should now be able to identify the circumstances in which a company director or an officer can be held personally liable, evaluate the client's risk profile to determine whether D&O policy should be discussed or raised with them, and to explain the core structure of a D&O policy. So thank you ever so much for your time, and we have finished actually on time today. But if you do have any questions, I haven't seen any come through into the chat or the Q&A. So if you do, please pop your questions in. If not, then from me, thank you ever so much for coming to listen to me for the last hour. I hope that you found it beneficial. Good luck with having conversations with your clients about D&O, or if all else fails, of course, you know where Protect Commercial are. Give them a ring. They're very aware of D&O insurances. We've just recently done making sure that everybody is happy and comfortable and recognizing and realizing what is actually available out there on the market. So they're all newly and relatively trained and refreshed on these areas. So thank you, everybody. Take care, and I will see you next on the next webinar in September. Thank you, everyone. Have a great day.